So what happened next? Well, almost 5 years after the events we just covered, the SEC sued Panuwat for insider trading. In general, an insider trading violation has the following elements: trading in securities on the basis of material, non-public information in violation of a duty of trust and confidence to the source of that information. Now, someone who was reasonably well informed about insider trading law could have assumed that trading in the securities of at least two companies would have been problematic for Panuwat. Trading in Medivation itself could have brought liability under the classical theory of insider trading, while trading in Pfizer could have given him legal exposure under the misappropriation theory. But what about Insight? They didn't even have a code name in this deal. Senior staff at the SEC swears this case isn't novel, but something new is going on here. The matter exposed at least two significant issues for the trial court to resolve. First was the confidential information Panuwat learned from Medivation material to his trading in the Insight call options. Panuwat argued that Medivation and Insight were just fundamentally different companies and that this information could not have been material to Insight. Meanwhile, the SEC pointed to news articles and analyst reports indicating that a scarcity of assets in the mid-cap oncology space could mean that Medivation's acquisition would boost the price of Insight shares. You'll remember that analysts and Medivation CFO had noticed this issue even before the acquisition was announced. Second, what was the scope of Panuwat's duty to Medivation? Did it include a duty not to trade in Insight? Remember, Insight was not part of this deal in any way. In its order denying Panuwat's motion for summary judgment, the trial court actually found three sources of this duty and said that any one of them would have been sufficient. One was a general, undocumented duty of trust and confidence that was created when Medivation entrusted him with confidential information. The confidentiality agreement that Panuwat signed was another. The insider trading policy he signed was a third. You may know that the SEC and the Justice Department frequently review internal corporate documents like these to identify how extensive these duties are. Here, the policy's terms restricted trading based on confidential information Panuwat learned from Medivation in the securities of any other public company, including all of Medivation's significant collaborators, customers, partners, suppliers, or competitors. The trial court was clear in saying that Insight did not have to be in one of those subsets. By its terms, the policy restricted Panuwat from trading in any public company. This holding that Insight did not have to be a Medivation collaborator, customer, partner, etc. to create a relevant duty of trust and confidence is probably what led to the defense bar's heads popping off. What if Panuwat had bought call options in Walmart or Meta instead of Insight? This idea is surely limited by the materiality required for insider trading liability. Could Medivation's information really have been material to the securities in those companies? Still, the policy's reference to any publicly traded company may now seem like a hole big enough to drive a truck through. This case gives companies and their executives a lot to think about regarding their compliance programs. We'll discuss the ramifications next.